As you have been told that a company is a juristic personality, a juristic person which is created by, in result of a fiction of law by operation of law in the form of registration of the company at the Security and Exchange Commission of Pakistan. And for creation and the registration of a company is known as incorporation. Incorporation. So for the purpose of incorporation or registration or creation of a company, certain essential documents are needed, and we talked about it in detail. Number one was the Memorandum of Association. And I told you last time that Memorandum of Association is the constitution of a company. It contains each and every detail about the company's setup and business. Number two, most important document which is needed for the registration of a company is Articles of Association. Articles of Association are in fact bylaws of the company. Or you can say that a memorandum of association regulates the relation of the company with outside world, while articles of association regulates the internal affairs of a company. So it deals with the internal administration. What does internal administration means of a company? You know that a company is a juristic personality, or it's an imaginary personality, having no physical existence, but it has existence in the eye of law, and it has rights and duties and liabilities like we have, like a natural person has. It can sell and buy in its own name. It can sue and be sued in its own name, and so many other things. But question here arises that how would it, you see, do all these acts when it has got no physical existence? Actually, it will, a company is represented, or a company acts through some natural persons, and those natural persons are known as its directors. And what are directors, how they are elected, from where they come into the scene, this is what we are going to talk about next time. But for the time being, let me tell you that, you see, there are directors and they are chosen by the shareholders from amongst the shareholders. And these are the people who act on behalf of the company. So articles provide details about the election of directors, their powers, their authorities, their everything about them, board of directors, their meetings, their quorum. Then there is another body which you see, which is there in the company, and that is called general shareholders. So there are meetings of shareholders, annual meetings and extraordinary meetings. So in these meetings, important decisions are conducted, important business are disposed of. There are certain matters which are dealt with or decided by the board of directors, but there are certain matters which can only be decided and disposed of by the shareholders in a general meeting of them. All right. So details about the meetings, its their procedures, their quorum, all these details are provided in the articles of association. In the same way, how the dividend, the profit earned by a company in the business is called dividend. How dividend is distributed among the members, what would be the procedure? This is also something which with which articles of association relate, or you see, discuss. So articles of association has been defined in section 2, paragraph 3. But as usual, it never gives you the true meanings of articles of association. If you go through, if you look at section 2, paragraph 3, it defines uh, articles of association as articles means the articles of association of a company framed in accordance with the company law or this act. Either they are framed by a company which is registered under this law, or the companies which were registered under other laws, the previous laws, companies laws, like Companies Ordinance 1984, Companies Act 2013, etc., etc. So this is what article of association means. Another important point which must be discussed today about articles of association is concerned that, look, whether it is article of association or it is you see, memorandum of association. Uh, if they are registered, they are alterable. They can be amended. They can be changed. So, memorandum of association as well as article of association can be changed whenever the company needed to introduce certain amendments into it. Okay. Section 36 talks about it. It provides, it says that there was just one uh, formality, one requirement for alteration. And I have already told you that amendment in the company law is known as alteration. It is called alteration. Law is amended, constitution is amended, but articles of association and memorandum of associations, they are, when they are amended, they are called to be altered. So section 36 says that a company may, by special resolution, alter its articles. Any such alteration so made shall be as valid as if originally contained in the articles and be subject in like manner to alteration by special resolution. So articles of association is not something which can't be amended, which can't be altered. They can be altered under section 36, but special resolution. Now question arises that what does special resolution mean? Board of directors cannot alter, you see, neither memorandum of association nor articles of association. This is the authority of shareholders. So shareholders can alter it in a general meeting. So whether this is annual general meeting or some extraordinary general meeting has been called by the directors for some important matters. And these alteration or these amendments can only be upheld if supported by a special resolution. A decision taken by the general meeting of shareholders, the general body of shareholders, is called resolution. So if all the 100% shareholders, they are in favor of alteration, well and good, but at least 3/4 of them must agree with it. If it is less than three-fourth, you see, then you see these alterations are not upheld, they are not incorporated, they are not accepted by the law or by the commission. What happens, you see, whenever an alteration is needed, the directors, they present it to the general body of the shareholders in a general meeting. And if they are passed by 100% majority, well and good, there will be no problem. But if there is a difference of opinion, some shareholders are in the favor of alteration and some are not, then a poll is conducted. A poll, I mean, votes are taken from the shareholders. If three-fourth majority is supporting, three-fourth majority is supporting the matter of alteration of articles, then it will be upheld. And a resolution passed by three-fourth majority is called special resolution. Three-fourths means if the number of members in a general meeting is 400 shareholders, 300 out of 400 must support alteration by special resolution. Okay. Now, the next issue or next topic for today's lecture is that if a company is, you see, initially registered as public company, whether it can be converted in future into a private company or not, or when a company is initially registered as private company, can it be you see, converted into a public company or not? Okay, so let's see. Yes, I mean, if a company has been registered as public limited company, it's never, I mean, it's never going to be a public company forever. Whenever you see the shareholders, they wanted to get it converted into a private company, they can do it. And this is under section conversion of public company into a private company, according to section 46. There are two requirements for it. If a public company is converted into a private company, but question arises here that why a public company should be converted into a private company? You see, because there are privileges and there are advantages of having business under public limited company, which a private company cannot have. For instance, the number of members cannot, a private company cannot exceed the number of shareholders beyond 50. While in the case of public company, the maximum number is unlimited, you see. Another important, you see, advantage of a public limited company is that public limited company can raise its capital from the public by offering its share for sale to the public, which a private company can't. Anyways, if just suppose there may be situations, there may be circumstances in which the company decides that it should convert itself into a private company, might be, you see, the business is not much good or for some other reason. Anyways, law allows a public company to convert itself into a private company, but there are, as I told you, two requirements. Requirement number one is prior approval of the commission for conversion. A public company may be, this is under section 46, paragraph 1, subsection 1, a public company may be converted into a private company if it has got a prior approval of the Security and Exchange Commission of Pakistan in writing. And such approval would be granted to the company on its application filed with the commission. So if a public company wanted to get itself converted into a private company, it would apply to the Commission, Security and Exchange Commission of Pakistan. And obviously, they are not going to allow every public company to convert itself into a private company unless the authorities at the Security and Exchange Commission of Pakistan are got convinced that, you see, this is I mean, essential for the company to convert itself into a private company. So number one requirement is prior approval. And number two is alteration of memorandum and articles of association. You see, first of all, prior approval, and when it is approved, then the second step is alteration of memorandum as well as of articles of association. Okay, and as you know that if for both the alteration of both the essential documents, a special resolution would be needed. You see, the characteristics of a public company would be removed. Like public company can offer its shares for sale. If it is being converted into a private company, then this is to be restricted. And it should be mentioned in the memorandum of association that this is a private company and obviously it cannot offer its shares to the public for sale. In the same way, so many other, you see, requirement like number of members would be reduced to 50 if it is beyond 40. So it is possible and very much possible under section 46. Sometimes what happens that a public company is converted compulsorily by operation of law. You see, without the application of shareholders or the board of director or the MD of the company to the commission, it is automatically, it is compulsorily, you see, converted. Section 46, subsection 5 talks about it. You know that, you see, where if a private company alters its articles in such a manner that they no longer include the provision which are required to be included in the articles of a company in order to constitute it a private company. So, you see, we talked about conversion of a public company into a private company. Coming to the case of a private company, conversion of a private company into a public company. And you know the essential characteristics, the chief characteristics of a private company is that it cannot transfer shares. In a private company, shares can't be transferred. And number two, essential, you see, or chief characteristic of a private company is that its number must be below 50. And number three is it cannot invite public to buy its shares. If just suppose in a private company, the articles of association and memorandum of association are altered, amended in such a way that these restrictions are removed, you see, then the company would compulsorily be, you see, converted from public company into a private company. Just suppose that an amendment is, you see, an alteration is introduced into the articles and memorandum of association, which removes the restriction of number of members. The number of members increases beyond 50, or where you see it allows transfer of shares. A private company, by alteration in the memorandum and article, allows transfer of share, which is against the constitution of a private company, or it removes the restriction. It starts selling, or it starts, you see, inviting public to buy its shares. So if these essential characteristics of a private limited company are removed, it would be, you see, it would become by operation of law as public company. What would be the effect of these amendments? If these amendments or these alterations are introduced into the articles and memorandum of association, its effect would be, I'm still in section 46, paragraph 5. It says that from the date of the alteration, such private company shall cease to be a private company. This is what is law says. Okay. And number two is it will legally be bound. When is, you see, either the number is increased from 50, or the restriction upon transfer of share is removed, or you see restriction upon invitation of public to buy its share is removed, then it will cease to be a private company. And when it will cease to be a private company, it will legally be bound to file with the registrar of companies at the commission two documents: a copy of the memorandum and articles of association after amendment, and number two, a copy of the special resolution through which the memorandum and articles are altered. Okay. And if it is not done, if you see the commission is not provided with these documents, then what is going to happen? If the default is made in complying with the provision of any of the preceding subsection, the company and every officer of the company who is in default shall be liable to a penalty not exceeding of level 2 on the standard scale. What are the levels of penalties? Leave it for the future. Anyway, this is this is an irregularity for which there is a penalty in the company law. That's why you see it has to be done by the companies